And welcome back. Will Worsham again with me. Good to see you again.
You too, Tom.
We're going to talk about something that so many people at one time or another, it does come into their mind, especially with the economy and everything the way, and that's bankruptcy. Now, I think people have an idea of what bankruptcy, filing for bankruptcy is, but it's not a one-size-fits-all situation here.
No, there's two different types of consumer bankruptcies. There's a Chapter 13 and a Chapter 7.
All right.
Chapter 13 is a repayment plan. You get a repayment plan for 3 to 5 years. You make payments, and at the end of your plan, it's designed to pay as much of your debt as you can, and when you're done, you get a discharge on the remaining debt.
Yeah, now, is that decided through the courts? You sit down with creditors?
It's a federal process. Your creditors do have input into the process, but ultimately a judge, along with what's called a bankruptcy trustee, is going to help make that decision.
Okay.
In any type of bankruptcy, including a Chapter 7, a bankruptcy trustee is appointed. They create what's called a bankruptcy estate, which is essentially your assets, and then they are in charge of kind of distributing those assets. They have a little bit of a bigger role in a Chapter 7, which quite frankly is what most people are familiar with and they're going to want to file.
Let's talk about Chapter 7.
Sure.
Yeah.
Chapter 7 is a fresh start. Essentially, the day that you file, your bankruptcy estate is created. And your assets go into that, and then the trustee administers that and has the right to distribute those assets, sell some property, and try to repay the debts that they can. Most people are going to file what we call a no-asset Chapter 7 bankruptcy, which is, I don't have any assets. That's why I'm bankrupt. So there's really not going to be anything for the trustee to distribute. Now, some people may be thinking, well, I do have assets. I have a car, I have a house, I have clothing, I have jewelry, all those things. Well, Missouri law, there are what's called exemptions in bankruptcy, and they apply to collection cases and to bankruptcy. So there are certain assets that a creditor, whether in bankruptcy or not in a bankruptcy, cannot seize in order to satisfy debts. So you get a certain amount of money that you get to reserve to have a home. You get a certain amount of money you get to have a car. You get to reserve certain jewelry, clothing, tools of trade, musical instruments, certain things. You get to keep a little cash. So the idea is not we're going to strip you down bare, take everything you've got.
Yeah, you're not on the street.
No, the idea is to give people a fresh start so that we can start over and get back on our feet and recover and contribute to the economy and all those things. Now, one of the most important things in bankruptcy is when you file, it's what's called an automatic stay.
All right.
There's an order by the bankruptcy court that requires all creditors to stop collection attempts immediately. That's one of the big benefits.
Yeah, so they can't keep calling you and say, hey, I want my money.
Exactly. If they filed a lawsuit, they have to stop proceedings and that. And that's really one of the big benefits, because the problem when people are considering bankruptcy is it's so frustrating. There's so much stress. And just the relief of, I've got these people to leave me alone for just a little bit, catch your breath, get a plan, and proceed is one of the real benefits of bankruptcy.
Once you file for bankruptcy, if you choose 7 or 13, can you change it at all in the future?
Yes, if it's necessary, if going through the process you realize a 13 is more appropriate or you realize a 7 is more appropriate, then that can be modified. And once again, your creditors can have some input into that too. If they say, now wait a minute, you filed for a 7, you've got a healthy income. You can repay these debts, and they may say, Judge, this shouldn't be a 7, this needs to be a 13, because they can repay some debts over time.
So it sounds like best idea, if you're considering it seriously, talk to an attorney.
Absolutely.
All right, and you can ask Will questions, legal questions. Just go to wworsham@color10.com, and he'll answer them every week right here on Ozarks Live.